Hello everyone, welcome to India4IAS. My name is Shreyas. In this video, we'll be discussing about 2021 Polity PYQs. PYQs important annadu namige gottide. Polity adrallu specially it is more important annadu kuda namige gottide. So as we proceed on in this video, we'll be seeing at the important topics that the UPSC has recurrently asked. Along with that, we'll identify what are the traps that UPSC normally gives in Polity section. So without wasting any time, we'll proceed with the session. First question, under the Indian Constitution, concentration of wealth violates which of the following? Right to equality, ये article under बरते article 14 to 19, 14 to 18, sorry. So does it deal with concentration of wealth? No, it doesn't. Right to freedom, which comes under article 19 to 22. Does it deal with concentration of wealth? No. Then the concept of welfare, which is a very broad theme. Yes, it includes a lot of other things also, but we'll see at the option B. DPSP. DPSP articles naming ಜ್ಞಾಪಕ ಇದ್ರೆ a direct hit question. Easily we could have scored 2 marks. DPSP, under DPSP, article 39, subclause C, which directly mentions that the state has to take measures to prevent the concentration of wealth. ನೋಡಿ DPSP ಪ್ರತಿ ಒಂದು ಆರ್ಟಿಕಲ್ ನಮಗೆ ಬಯಾಟ್ ಇರಬೇಕಾಗಿರುತ್ತೆ. 51, 50, 49 these are easy, but when it comes to article 38 and 39 there are so many provisions, but at least on broad idea ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. For instance, article 39 under right to livelihood ನ ensure ಮಾಡಬೇಕು. So ethics ಅಲ್ಲಿ ಕೂಡ if you are writing the mains answers, whenever some worker is been denied of the minimum wages by his employer, then we can use that under article 39 clause A, right to livelihood has not been ensured, so it becomes an unethical act. ಈ ತರ ಕೂಡ ನಾವು ಮೇನ್ಸ್ ಅಲ್ಲಿ ಯೂಸ್ ಮಾಡಬಹುದು. So article 39 under right to livelihood, right to ensure healthy right to develop opportunities for the children, to ensure the health of men, women, workers, ivella provisions ide. Equal pay for men and women for equal pay. All these articles, all these provisions, they come under article 39 subclauses. So idu namige bayat irbeku. Because DPSP is very important topic, so UPSC could directly pick article from the DPSP and ask frame a question on it. Article 39, like I spoke of, right to adequate means of livelihood, equal pay for equal work, to ensure health and strength of workers, men, women, and children had to be given opportunities to develop themselves. So all these articles barate. Broadly ಏನate article 50, 51 ಇವೆಲ್ಲ broadly mention ಆಗಿದೆ in short lines, so we remember only those ones, but 38, 39 ಇದರಲ್ಲಿ ತುಂಬಾ implicitly so many things have been fit in, so ಇದನ್ನ ನಾವು neglect ಮಾಡ್ತೀವಿ. Please do not do that mistake. We'll move on. What is the position of right to property in India? Right to property question. So it is a legal right available to citizens only, legal right available to any person, fundamental right available to citizens. See, we should know it is no more a fundamental right. Once upon a time it was fundamental right, then by 44th amendment it was taken out of the fundamental rights. It is neither fundamental right nor legal right. You know that right to property is still in the constitution under article 300A. So it is not a legal right, becomes wrong. You can call this as legal right. Right to property is now a legal right or a constitutional right. You can call it either ways. So the only confusion should have been legal right available to citizens only and legal right available to any person. Ee question alli maximum jana mistake madidru during the actual exam. The answer to this is it is a legal right which is available to any person. This has been mentioned in the constitution itself, but the conventional books that we study did not focus upon this aspect, so that is why UPSC picked it up. So it is available to any person and not just to the citizens. So right to property bagge, if we have to know a couple of other things, right to property was initially in the original constitution, it was under article 19 and article 31A. Article 19 ಮತ್ತೆ 31 sorry, article 31 ಅಲ್ಲಿ ಇತ್ತು, then we took it out and we put it under article 300A. So what is the difference? Earlier it was fundamental right, now it is not a fundamental right. So does it mean that it can still be enforced? Yes, it is a constitutional right or a legal right that still has enforcement, but just that to enforce that a person cannot directly approach the Supreme Court or the High Court like it was earlier when it was a fundamental right. Now they will have to go to subordinate courts, and likewise they will have to go to High Court and then Supreme Court. So that is the difference that is present now. So we'll see the explanation. Right to property, 44th Amendment, 300A. What is the status now? 300A. It is under Article 300A. One more thing, right to property, when can it be denied? Idr ಮೇಲೆ ಇನ್ನೂ question ಬಂದಿಲ್ಲ, they could frame it this way. Right to property, can it be denied by arbitrary executive action? No. Supreme Court has told that right to property can be denied only by a legislative act and not by executive action. So if there is any arbitrary executive action, from that right to property is been protected. But if there is an arbitrary legislative action or a law that is been made, then the right to property is not been guaranteed. This is the difference. But right to property normal section ಮತ್ತೆ minorities ಗೆ rights slightly different ಇದೆ. Right to property of minority educational institutions are been directly protected under Article 30. So it is still a fundamental right. So right to property of minority institutions is a fundamental right. But in general right to property for the other sections, it is a constitutional right and not a fundamental right. ಇಷ್ಟು ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. We'll see the next question. What is the exact constitutional status of India as of 26 January 1950? So 1950, what was the status of India? Was it democratic? Yes. Was it republic? Yes. Was it sovereign? Yes. Was it secular? No. Secular, socialistic and integrity. These three terms were added by 42nd Amendment of 1976. So secular irlilla, socialist irlilla, democratic ittu, republic ittu, sovereign ittu, democratic ittu, republic ittu. See, UPSC shouldn't have framed such questions because both options are correct, but comprehensive option would include this because sovereign is not present in option A, right? So what was the exact constitutional status of India on 26 January 1950? Sovereign means India has the freedom to take its own decision. There is no other power over it which will control it, like it was during the colonial time. Democratic means supreme source of power are people. Republic means the head of the state shall be elected and he does not derive the power from its birth, and any person or any citizen of India is eligible to become the head of the state. Head of the state nam kesal president, right? Also a couple of other things if I wanted to speak of is, see, sovereign, democratic, republic ittu, then socialist, secular and integrity words were added by 42nd Amendment. Also Constitutional Day, 26 November is been celebrated as the Constitutional Day every year because 26 November is the day when the Constitution was adopted. It is also known as National Law Day. These are a couple of other things which we should have known. Moving further, a constitutional government means, see, earlier class allo we spoke of this, ಈ ತರ ಕ್ವಶನ್ಸ್ ಕೊಡೋದೇ ಆಸ್ಪಿರೆಂಟ್ಸ್ ಗೆ ಕರೆಕ್ಟ್ ಆಗ್ಲಿ ಅಂತ. ಸೊ ಈ ತರ ಕ್ವಶನ್ಸ್ ಅಲ್ಲಿ ವಿ ಕೆನಾಟ್ ಅಫೋರ್ಡ್ ಟು ಮೇಕ್ ಮಿಸ್ಟೇಕ್. ಸೊ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಗವರ್ಮೆಂಟ್ ಮೀನ್ಸ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಗವರ್ಮೆಂಟ್ ಆಫ್ ಅ ನೇಷನ್ ವಿತ್ ಅ ಫೆಡರಲ್ ಸ್ಟ್ರಕ್ಚರ್. Okay, a government whose head enjoys nominal powers. Okay, a government whose head enjoys nominal. Okay, there has been repetition. I think it's my mistake. A government limited by in terms of the constitution. Constitutional government means a government which functions under the constitution, that it cannot go above it. So it is a limited government by definition, a government which has been limited by the constitution. So in India also the same thing has been followed. It is the constitution which is supreme over other organs of the state, be it judiciary, be it legislative section, or be it the executive wing. So constitutional governmentally the government of the day is been constrained by the constitution. So government does not exercise supreme power. Its power is been limited by constitution or the law which itself made, or by judicial review, or by basic structure which the Supreme Court has given. So same thing, and when we have a constitutional government or we want the constitution to be supreme, there are other things also that needs to be done. There needs to be an independent judiciary, because judiciary is the protector and the interpreter of the constitution. So we want a strong judiciary, a committed and independent judiciary which shall keep a set of checks and balances whenever there is arbitrary executive action or legislative action that has been taken. Likewise, for constitution to rule or for the constitution to be supreme, we need the separation of powers. We need separation of power between legislative, judiciary and executive wing, so that each one of them keeps checks and balances upon each other, so that no one takes all the power within itself. So idu kuda important agirutte, idinne different way alli kelbodu. So that's why I wanted to mention. Moving ahead, see in the 2021, if you see 2020, 2019, 2018, 17, 16 ivella questions nodidre awards mele question bandirilla. 2021 alli bantu. So this was sort of bounces because we were not prepared for it. Last 6-7 years pattern ನೋಡ್ತೀವಿ, ಅವಾರ್ಡ್ಸ್ ಬಗ್ಗೆ ಕ್ವಶನ್ ಇರಲಿಲ್ಲ, ಬಟ್ ಹಿಯರ್ ದೇ ಹ್ಯಾಡ್ ಆಸ್ಕ್ಡ್. ಸೊ ಇದಾದ್ಮೇಲಿಂದ ಸ್ವಲ್ಪ ಕ್ವಶನ್ಸ್ ಈ ತರ ಬರ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ, ಸ್ಪೋರ್ಟ್ಸ್ ಮೇಲೆ ಬರ ಸ್ಟಾರ್ಟ್ ಆಗಿದೆ. ಸೊ ಎನಿ ಟೈಮ್ UPSC could pick up new themes because every time it will have to come with 4-5 very difficult questions. So instead of that, it is coming up with new themes which we do not study. See, Bharat Ratna and Padma awards. Bharat Ratna awards are titles under Article 18. See, Article 18, fundamental right, which speaks of abolition of titles. It does not provide for titles, rather it speaks for its abolition. So A wrong aito. Which of the following is not correct ಅಂತ ಕೇಳಿದ್ದಾರೆ. Padma awards which were instituted in the year 1954 were suspended only once. So UPSC traps ಅಲ್ಲಿ ಕೊಡುತ್ತೆ only, ಮತ್ತೆ number ಅಲ್ಲಿ ಕೊಡುತ್ತೆ. The number of Bharat Ratna awards is restricted to a maximum of 5. So in case if we had not studied this, but if we knew where does UPSC give traps, how we could have attempted. Bharat Ratna awards under Article 18 ಬರಲ್ಲ ಅನ್ನೋದು ನಮಗೆ ಗೊತ್ತಿರಬೇಕು, because it's a basic fundamental right. So option A wrong ಅಂತ ಗೊತ್ತಾಯಿತು. Padma awards suspend ಆಗಿದೆ because we would have come across at least Indira Gandhi government when it was been suspended. But how many times suspend ಆಗಿದೆ ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. It is telling only once. Because of this only we could have taken it as wrong. The maximum number of Bharat Ratna awards is restricted to maximum of 5. So ಇಲ್ಲಿ ಕೂಡ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. If you are not sure of the number, then we could have taken it as wrong and we could have marked option D as correct, and it would have been correct if you had done this during the actual exam condition. So couple of things if you had to learn about the Padma and the Bharat Ratna awards. See, Padma awards are 3 categories ide. Padma Vibhushan which is at the top, then Padma Vibhushan top, Padma Bhushan second, then Padma Shri. So it is given to people who have given distinguished service across various fields. Ivella admel barodu Bharat Ratna, which is the highest award that is given in the country. Bharat Ratna award every year kodbekannadeniilla, and usually it is been followed that usually a maximum of 3 persons are given Bharat Ratna award, but it is a conventional practice. It is not been mandated by any law or constitution. So that is why a couple of years ago when Bharat Ratna was been given, it was given for 5 persons together. 4 of them were politicians and 1 other person was M.S. Swaminathan. And Padma awards, they are given on the occasion of Republic Day, January 26th. So istu one basic idea namage idre saku. Beyond this, if you want to go, that is left to you. And under Article 18 also, it is not that state will not permit to have any names. It will permit only military and academic distinctions only, and rest of the names are not to be conferred. So we'll move ahead. With reference to India, consider the following statements. A question on judicial custody. New thing. See, ivella governance part alli barutte, judicial custody barutte, munde innond question parole anta barutte. So 2021 Polity section was a little bit moderate or tough. It was in that between moderate and tough level. Tumba easy anta helakala, kelu questions easy ittu. Just like we saw what was status of constitution, these were basic questions. But idu governance questions. So idನ್ನ ನಾವು ಕಾಮನ್ ಆಗಿ ಮ್ಯಾಗಝಿನ್ಸ್ ಅಲ್ಲೆಲ್ಲ ಓದಲ್ಲ. So we had to think it on spot when we went there. Judicial custody means accused is in the custody of the concerned magistrate. Okay, and such accused is locked up in police station, not in jail. See, ಇನ್ನೊಂದು UPSC, it will give it is so and so but not so and so. So and so but not so and so ಅಂತ ಕೊಟ್ಟಾಗ be extra cautious, because this is one of the areas where UPSC give traps. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Not ಅಂತ ಹೇಳಿದ್ದಾರೆ. So ಇಲ್ಲಿ ಕೂಡ extra careful ಆಗಿರಬೇಕು. So we'll look what is it. So judicial custody, accused is in custody of magistrate. So judicial ಅಂದಿದ್ದಾರೆ, magistrate custody ಅಂದಿದ್ದಾರೆ, this is fine. But the accused is locked up in police station. See, police ಮತ್ತೆ magistrate till match ಆಗ್ತಿಲ್ಲ. If he was locked up in police station, why not say police custody? Why say judicial custody? So this is actually wrong. He will not be locked up in police station. Rather, he will be locked up in jail. ಇಲ್ಲಿ statements ಅಲ್ಲಿ ಅರ್ಧ ಸೆಂಟೆನ್ಸ್ ನ ಬೇರೆ ಕಡೆಯಿಂದ ಪಿಕ್ ಮಾಡಿ ಇಲ್ಲಿ ಜಾಯಿನ್ ಅಪ್ ಮಾಡಿದ್ದಾರೆ. During judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of court. See, bari ishtane nodbedi. Look at the full sentence. Without the approval of court, judicial custody is under magistrate. So police will need the permission of the court. Simple age ide. This is correct. Ee tara we could have thought when we were actually solving, when we were actually attempted this question during the exam condition. So judicial custody, police custody ಬಗ್ಗೆ ಮಾತಾಡಬೇಕಂದ್ರೆ, see, police custody means the person or the accused is in the custody of the police. He will be in the police lockup and not in the jail, and he can be kept in the police custody or in the police lockup for a maximum of 24 hours. So ee 24 hours alli police FIR file ಮಾಡಬಹುದು. They can investigate the accused person and get to know things from him. But 24 hours ಅಷ್ಟೇ max. ಅದಕ್ಕಿಂತ ಬಿಯಾಂಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಬೇಕಂದ್ರೆ ಕೋರ್ಟ್ ಇಂದ ಆರ್ಡರ್ ತಗೊಂಡ್ಬರ್ಬೇಕು. But when it comes to judicial custody, the accused is in the custody of the magistrate. So in that case, if the police wants to do investigation, he has to take the permission of the court, and he cannot do without it. So ya case alli police custody agutte, ya case alli judicial custody agutte. This depends upon cognizable and non-cognizable offense. See, ee tara kelidare, next cognizable, non-cognizable kuda kelbodu. Cognizable offense. See, cognizable offense means these are offenses which are more heinous, such as murder. So cognizable offense alli there is no warrant that is being needed. So without warrant also police can do the, no warrant is needed, so police can easily do the arrest. So in this case he will be under police custody. But if it is a non-cognizable offense, then before arresting the person, the police will have to take an order from the court, and only after that they can do the arrest. But cognizable, these are more heinous crimes. So in that case, the police will have to quickly arrest them without waiting for the court order. We'll move ahead. Right, police custody maximum of 24 hours. Same thing with judicial custody. But he'll need permission from the court to do the same. We'll move to the next question. With reference to India, which of the following statements are correct? When a prisoner makes out a sufficient case, parole cannot be denied. Trap areas cannot be denied because it becomes a matter of right. Next, state government have their own prisoner release on parole rules. See, basics namge ಏನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೂ at least we should know that prison is a state subject. So if the state governments are allowed to make their own prison rules, there's nothing which is wrong about it. So this will have to take it as correct. When a prisoner makes out a sufficient case, parole ಬಗ್ಗೆ ಆಲ್ರೆಡಿ ಗೊತ್ತಿದೆ. So many ಕನ್ನಡ ಮೂವೀಸ್ ಅಲ್ಲಿ parole ಇಂದ ಹೊರಗಡೆ ಬಂದ್ರು ಅಂತ ಎಷ್ಟೊಂದು ಸತಿ ಶೋ ಕೇಸ್ ಮಾಡಿದ್ದಾರೆ. So parole means there is temporary suspension of the term. ಅವನನ್ನ ಅಕ್ಯೂಸ್ ನ ರಿಲೀಸ್ ಮಾಡಿಲ್ಲ, ಬಟ್ ಟೆಂಪರರಿಲಿ he has been allowed to go outside of the jail. So parole cannot be denied to a prisoner because it becomes a matter of his right. See, just think, first of all, he is in jail because he had committed a crime, and that person, will it be right to give that person his right to go out of the jail? What if he escapes, or what if he goes and commits another crime? So it cannot be given as a matter of right. So even if we think in this way, we could have easily answered this. We cannot give such accused it as a matter of right. Rather, we can give it to only those persons who prove their good behavior through years of being in jail. So it becomes a matter of discretion to give right of parole. It could be given to certain persons if they trust, if the authorities trust them, or it can be denied to other persons. So idu wrong. One more thing, along with parole, there is something called furlough. See, ಒಂದು parole, ಇನ್ನೊಂದು furlough. See, basic idea ಗೊತ್ತಿರಬೇಕು, because ಇದ್ರ ಮೇಲೆ ಬಂದಿದ್ರೆ ಕ್ವಶನ್ ಇದ್ರ ಮೇಲೂ ಬರ್ಬೋದು. See, parole cannot be given, it is not a matter of right, but when it comes to furlough, it is a matter of right. So what are these? See, parole ಯಾವಾಗ ಕೊಡ್ತಾರೆ? If the person, if it is very very important, such as if the person is suffering from mental illness, if the person's family members, someone dies, then the person is allowed to go attend the rituals and so on. But furlough, it becomes a matter of right because it is given to those persons who have been in jail for a very very long period of time. So just to prevent them from suffering from any mental illness, or from retaining, or if they want the person to maintain his social ties with his family, then for a certain period of time he's been left out. So furlough is a matter of right, but parole isn't. But both of them can be denied depending upon who the accused is. Right. So if you have to look at the explanation, the same thing. For all is a matter of right and parole isn't. And state governments they have their own prison rules. See, parole, furlough, all these are dealt with the Prisons Act that has been there. Almost 19th century Prison Act ide. So under this, all of these things have been dealt with, and the Prison Act gives the power of prison and the prison rules under the state government. So each state government can have its own rules when it comes to parole and furlough. We'll move on. At the national level, which ministry is the nodal ministry to ensure effective implementation of scheduled tribes and other forest dwellers? So forest dwellers, see, general confuse agidru between environment and between Ministry of Tribal Affairs. Answer is Ministry of Tribal Affairs. See, this is a fact. And when we thought of tribes in our mind or the forest dwellers, the thing of tribal affairs should have been in our mind. This was a very simple question. So idr mele question bandide andre FRA Act provisions mele kuda we can expect. So we'll have to know basic things about FRA Act 2006. See, FRA Act 2006 yarig rights ide. See, there will be certain forest dwellers and certain forest scheduled tribes which would have inhabited a certain forest for so many years. Their ancestors have been cultivating the forest, protecting the forest for so many years. So a case alli, if the person's family has cultivated or been in that area for more than 3 generations, one generation 25 years anta tagontivi. If it's more than 3 generations, which is more than 75 years, then in whichever forest area that he had occupied or cultivated, adralli 4 hectares land na avarge ownership kodtivi to that forest dweller. And this ownership of 4 hectares, it could be passed on to their offsprings or sons and daughters also, but it cannot be sold to other private party. So along with forest rights in FRA Act, there is individual rights and there are collective rights. So individual rights alli right to property il bantu. He will have 4 hectares of land upon a person's name, and this is maximum of 4 hectares. They can even get less than this. And what are the collective rights? They will have the right to collect minor forest produce. Minor forest produce, they will have the right to collect, and also they will have the right to protect the environment or the forest. So there are individual rights, there are collective rights, and the extent of rights of each of these will be decided by the Gram Sabha of the particular area. So see, Gram Sabha will determine the extent of rights. At least 3 generations ಮಾಡಿರಬೇಕು, which is 75 years. ಟೈಟಲ್ ಇರುತ್ತೆ, 4 hectares ಲ್ಯಾಂಡ್ ವರೆಗೂ ಸಿಗಬಹುದು, ಯೂಸ್ ಸಿಗುತ್ತೆ, ಮೈನರ್ ಫಾರೆಸ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ನ ಯೂಸ್ ಮಾಡಬಹುದು. They will have the right to rehabilitate if there is illegal eviction or forced displacement. So ಇಲ್ಲಿ right to property aspect na ಇಲ್ಲಿ protect ಮಾಡಿದ್ದಾರೆ. Likewise, they will have right to forest management. They can regenerate, conserve, protect, all those things are there. Right, so we'll move ahead. A legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law. Application of law, when it comes discretionary power, it violates which one of the following articles of the Constitution of India? So legislation which confers an unguided discretionary power when it comes to application of law violates which of the following? See, Article 44 is Uniform Civil Code. This is not in the picture. Article 28 is religious rights. So this is also not the answer. In the actual exam, aspirants were confused between option A and option C. But during the exam condition, when we have less time, many of us we went for option C, thinking of Article 32. Article 32 tells that if there is violation of fundamental rights, then we can go to High Court or Supreme Court. So right to constitutional remedies has been given under Article 32, but it is Article 32, the power of High Court or Supreme Court under Article 32 is only limited to the enforcement of fundamental rights and not any other right. Article 14 bari mind al bandirad right to equality ಅಷ್ಟೇ ನಮ್ಮ ಮೈಂಡಿಗೆ ಬಂದಿದೆ. ಬಟ್ ಆರ್ಟಿಕಲ್ 14 ಇನ್ನೂ ಸ್ವಲ್ಪ ಬ್ರಾಡ್ ಆಗಿ ಥಿಂಕ್ ಮಾಡಿದ್ರೆ, ಫ್ರಮ್ ವೇರ್ ಡಿಡ್ ವಿ ಪಿಕ್ ದಿಸ್ ಆರ್ಟಿಕಲ್ 14? We picked it from the concept of rule of law of Dicey, British personal. So rule of law, British case ಅಲ್ಲಿ 3 aspects were applicable, but in the case of India, there were 2 things which were applicable, in which one of them was absence of arbitrary power. Absence of arbitrary power. Arbitrary power. ಈ ಆಸ್ಪೆಕ್ಟ್ ಏನಾದ್ರು ಎಕ್ಸಾಮ್ ಅಲ್ಲಿ ಮೈಂಡಿಗೆ ಬಂದಿದ್ರೆ, so article 14 deals with the absence of arbitrary power, which is the same as unguided, uncontrolled discretionary power. So in that sense, people would have answered 14. But exam ಅಲ್ಲಿ narrow think ಮಾಡಿದಾಗ only article 32 ಮೈಂಡಿಗೆ ಬಂದಿರುತ್ತೆ, that there will be court which will prevent that such a law to happen. ಆದರೆ ಇಲ್ಲಿ ಬ್ರಾಡ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ and fundamental rights ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ. So answer is 14 and not 32. If this aspect had come to our mind when we thought in the exam, then we would have got it correct. Same thing, concept of equality of law, it includes 2 things, absence of arbitrary law and equality before the law, which is the equal subjugation of all citizens under ordinary law. We'll move to next question. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? Federal means there is division of power between a central government and a regional government. In our case, it is state government, or even you can consider a local government. So independence of judiciary, union legislature has elected representatives. Federal feature anta ಹೇಳಿದಾಗ union legislature has elected representatives, that doesn't make it federal. Union cabinet can have elected representatives. Even this is not related to federalism. The fundamental rights are enforceable. Fundamental rights ಮತ್ತೆ federalism direct relation alla. So likewise I said, if we want the supremacy of the constitution, or if we want the federal structure to be intact, then we need an independent judiciary which will resolve the disputes between the center and the state, and which will be neutral when it is deciding the disputes between these two. So we want an independent judiciary so that center is not able to influence the judiciary when it comes to dealing with the states. So this is the right answer. Also federal features ಬಗ್ಗೆ ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. Dual polity, like I said, dual polity, written constitution. Why do we need written constitution? So that it is very well intact and it becomes very difficult to change it. Oral constitution such as British ಅಲ್ಲಿ ತುಂಬಾ ಈಸಿಲಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಚೇಂಜಸ್ ನ ಮಾಡಬಹುದು, ರಿಟರ್ನ್ ಅಲ್ಲಿ ಮಾಡೋದು ಕಷ್ಟ. ಡಿವಿಷನ್ ಆಫ್ ಪವರ್ ಇರುತ್ತೆ, ಎಸ್ 7 schedule ಅಲ್ಲಿ ಇದೆ, 7 schedule ಅಲ್ಲಿ ಇದೆ. Supremacy of constitution, if the constitution is supreme, then the center cannot influence its power over the state, because it has been mentioned in the constitution and only that much it can exercise. If the constitution is rigid, that is also good, because center cannot easily make amendments. Bicameral legislature, why is this there? Because Rajya Sabha is called the Council of States. So it is the responsibility of the Rajya Sabha to ensure that the interests of the states are being maintained or protected, and we need independent judiciary. All of these are the provisions. ಇದನ್ನೇ ಬೇರೆ ರೀತಿ ಕೇಳಬಹುದು. Bicameralism usually people miss out, so this is one thing which we need to know. So which one of the following defines the term state? Which one of the following defines the term state? NCERT ಓದಬೇಕು ಅಂತಾರಲ್ಲ, ಇಲ್ಲಿದೆ NCERT ಕ್ವಶನ್. ಸ್ಟೇಟ್, ಸಿ ಇದನ್ನ ನಾವು ಎಲ್ಲೂ ಇದರಲ್ಲಿ ಯಾವ ರೀತಿ ಕೇಳಿದ್ರೆ ಅದನ್ನ ನಾವು ಎಲ್ಲೂ ಫೋಕಸ್ ಮಾಡಿರಲ್ಲ. We look at the options. This question was picked from the NCERT and this was one of the rarest questions, because NCERT in question ಬರೋದು hardly ತುಂಬಾ ಕಡಿಮೆ ಆಗಿದೆ, but this was picked from NCERT and that is why many students started studying NCERT after this. We look at the options. A society permanently living in a definite territory with a central authority. For state, do we need a central authority? We do not. A number of persons who have been living in a definite territory for a very long time. State formation agake very long time, is it a necessity? No. State formation could be for short duration also, but state will have other aspects which are needed. So ಇದು wrong. Confusion ಆಗಬೇಕಾಗಿದೆ A ಮತ್ತೆ B ಮಧ್ಯ. Community of persons. So community of persons permanently occupying a definite territory. They are independent of external control and they have an organized government. This was one of the things. Other is a politically organized people. See, definite territory is fine. Possessing an authority to govern them. Authority ide, okay. Maintain law and order and protect their natural rights and safeguard their means. What if there is sometimes what if there is non-maintenance of law and order? So state, does it lose the status of state? No. Also politically organized, is it always a necessity? ನೋ. ಸೊ ಈ ಎರಡರ ಮಧ್ಯೆ ಚೂಸ್ ಮಾಡೋದು ಎಕ್ಸಾಮ್ ಕಂಡೀಷನ್ ಅಲ್ಲಿ ತುಂಬಾ ಟಫ್ ಇತ್ತು. ಬಟ್ ಈ ತರ ಮೈನ್ಯೂಟ್ ಥಿಂಗ್ಸ್ ಮೇಲೆ ನಾವು ಫೋಕಸ್ ಮಾಡಿ ಮೇ ಬಿ ದಿಸ್ ಇಸ್ ನಾಟ್ ದ ಥಿಂಗ್ ಅಂತ ಅನ್ಕೊಂಡಿದ್ರೆ ವಿ ವುಡ್ ಹ್ಯಾವ್ ಗಾನ್ ಫಾರ್ ಎ, ಬಿಕಾಸ್ ಎ ಇಸ್ ದ ರೈಟ್ ಆನ್ಸರ್. For a state, there are 4 conditions that needs to be met. There has to be people. For a state, there are 4 conditions, and this has been picked from the NCERT. There should be community of people, which is the population. There should be a definite territory. There should be a government, and it should be free to make its own decision, which is sovereign. So these are the 4 conditions which constitutes a state. ಇದನ್ನೇ ಅವ್ರು ಬೇರೆ ರೀತಿ ಅಲ್ಲಿ ಕೇಳಿದ್ದಾರೆ. ಸೊ NCERT ಇಂದ ಕಂಟೆಂಟ್ ನ ಪಿಕ್ ಮಾಡಿ they have formulated a application question. We'll move on. With reference to Indian judiciary, any retired judge of Supreme Court of India can be called back to sit by the Chief Justice of India. See, trap ಕೊಡಂಗಿದ್ರೆ ಇಲ್ಲಿ ಕೊಡ್ತಾರೆ, ಚೀಫ್ ಜಸ್ಟಿಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಯಾರು ಅನ್ನೋದು ನಮಗೆ ಕ್ಲಿಯರ್ ಆಗಿ ಗೊತ್ತಿರಬೇಕು. With the prior permission of the president. Now this is a correct statement. High Court in India has the power to review its own judgment as the Supreme Court does. Now this is a confusing thing. Why? I'll tell you. First, retired judge of Supreme Court. See, one retired judge of Supreme Court can be called back by Chief Justice of India with the prior consent of the President, and this power has been given in the Constitution itself. So retired judge bandaga Chief Justice of India, ad hoc or temporary judge anta bandaga it is Chief Justice of India who will do it with the prior consent of the President. But when it comes to additional judges, the appointing authority is not CJI. It is President himself. So ಈ ತರ ಕನ್ಫ್ಯೂಸ್ ಮಾಡಬಹುದು, ಗೊತ್ತಿರಬೇಕು. Right? President himself. See, High Court in India has the power to review its own judgment, just like Supreme Court. Supreme Court has the power to review its own judgment under Article 32. Right? Or Article 32. But does High Court has the power to review its own judgment? This is what we had studied. We studied in institute books. We studied in books that High Court also has the power. Even Kerala High Court has said the same. That it said that High Courts in India have the power to review its own decision. But UPSC, when it took out the key, go to 2021 and see in set A, it's question number 88, I suppose. Go and see the key. UPSC is telling answer is A. This is what the issue becomes. Sometimes UPSC takes out controversial answer key and there is no accountability for that. So ಎಷ್ಟೊಂದು ಜನ 1991 ಮಾಕ್ ಟೆಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆನ್ಸರ್ ಕೀಸ್ ಅಲ್ಲಿ 1992 ಮಾರ್ಕ್ಸ್ ಅಲ್ಲಿ ಇದ್ದವರು ಈ ತರ ಒಂದು ಕ್ವಶನ್ ರಾಂಗ್ ಆಗಿದ್ರಿಂದ ಎಷ್ಟೊಂದು ಜನ ಪ್ರಿಲಿಮ್ಸ್ ಕಟ್ ಆಫ್ ನ ಮಿಸ್ ಮಾಡಿ they failed in prelims. So this is one issue which happens. So please always target 3-4 marks above the cutoff or more than that to be in the safer zone. With reference to Indian judiciary, okay, this is what we discussed. See the same thing. Now under Article 226 of the Constitution, High Court has the power to review its own judgment, and also the Kerala High Court had also said the same, that it's a court of record and it could review its own orders. But UPSC did not consider this thing. Just like yesterday I spoke about another controversial key which a UPSC took out, which said that judicial review is been provided under the Constitution. Adanna UPSC wrong anta tagondide. But we studied that yes, judicial review is been provided under Article 13. So ee tara UPSC controversial key tegiyo chances irutte. And rest of the things are same as we discussed. With reference to India, consider the following statements. There is only one citizenship. There is only one citizenship and one domicile. See, ಇಲ್ಲಿ ಓನ್ಲಿ ಅಂತ ಬಂದಿದ್ರು ಇಲ್ಲಿ ನಮಗೆ ಕನ್ಫ್ಯೂಷನ್ ಆಗಬಾರ್ದು. ಇಂಡಿಯಾದಲ್ಲಿ there is only one citizenship and one domicile, and the domicile is of India and not of any state like Karnataka, Telangana or Madhya Pradesh. A citizen by birth only can become the head of the state. Citizen by birth only can become the head of the state. ಇಂಡಿಯಾದಲ್ಲಿ ಇದು ಫಾಲೋ ಮಾಡ್ತೀವಿ. ಹೆಡ್ ಆಫ್ ದ ಸ್ಟೇಟ್ ಮೀನ್ಸ್ ಪ್ರೆಸಿಡೆಂಟ್. ದಿಸ್ ಈಸ್ ಫಾಲೋಡ್ ಇನ್ US and not in India. A person even by naturalization can become a head of the state in India. So this becomes wrong and this becomes correct. Foreigner once granted citizenship cannot be deprived of it under any circumstance. Cannot be deprived under any circumstances. See, a foreigner may be granted citizenship but will have to keep certain grounds where their citizenship could be eliminated, because if they do any bad deeds. See, disrespecting the Constitution, national flag, all these things are aspects which we'll need to keep in mind so that we can terminate their citizenship if they do not follow this. ಸೊ ಒನ್ಸ್ ಗ್ರಾಂಟೆಡ್ ಕೆನಾಟ್ ಬಿ ಡನ್ ಅಂಡರ್ ಎನಿ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್. ಈ ತರ ಎಕ್ಸ್ಟ್ರೀಮ್ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಇರುತ್ತಲ್ಲ, ಇದು ರಾಂಗ್ ಆಗಿರುತ್ತೆ. ಜಸ್ಟ್ ಲೈಕ್ yesterday we discussed someone who is imprisoned for more than 5 years, then that means that he has been disqualified for the rest of his life to contest. So that is also wrong. So ಈ ತರ extreme things ಕೊಟ್ಟಾಗ we'll have to take it as wrong in the general case. So in this case 1 is correct, 2 is wrong, 2 is wrong, 2 is wrong, 1 is correct, and only 1 is correct. So answer is A. Other things which could be asked on citizenship which we do not come across normally, adanna ondsati nodana. One thing, citizenship is under the union list, so only parliament will have exclusive power when it deals with the power to do provisions on citizenship. Constitution does not define the term citizenship. Idanne UPSC ಏನು ಮಾಡಿ ಕೇಳುತ್ತೆ, Constitution defines the term citizenship ಅಂತ ಕೊಡುತ್ತೆ, right? ಮತ್ತೆ citizenship ಬಗ್ಗೆ ಬಂದಾಗ what is there in Constitution and what is there in Citizenship Act 1955, ಇದು ನಮಗೆ ಗೊತ್ತಿರಬೇಕು. The 5 grounds or 5 mechanisms through which one can acquire citizenship. Citizenship by birth, by descent, by naturalization, by registration, and by incorporation of territory. These things are not mentioned in the Constitution. These are mentioned in the Citizenship Act 1955. Likewise, what are the grounds on which citizenship could be renunciated, terminated, or been deprived? These grounds are also there in Citizenship Act 1955. ಇದನ್ನೇ ಏನ್ ಮಾಡುತ್ತೆ UPSC that these are mentioned in the Constitution ಅಂತ ಕೊಡ್ತಾರೆ. ನಾವು ಈ ಪಾರ್ಟ್ ಮೇಲೆ ಮಾತ್ರ ಫೋಕಸ್ ಮಾಡ್ತೀವಿ, ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬಗ್ಗೆ ಥಿಂಕ್ ಮಾಡಲ್ಲ, ಅವಾಗ ರಾಂಗ್ ಆಗುತ್ತೆ. ದಟ್ ಇಸ್ ವೈ ಐ ವಾಂಟೆಡ್ ಟು ಸ್ಪೀಕ್ ಆಫ್ ದಿಸ್. Citizens in India owe allegiance only to the union. This is also there because of the citizenship being under the union list. There is no separate domicile for any state wise. This is also there. And another thing is citizenship provisions. They were enforceable or they came into force from November 26th, 1949 itself and not from January 26, 1950. Idu kuda UPSC ಕೇಳಬಹುದು that citizenship provisions came to force from January 26, 1950. So ಇಲ್ಲಿ ಟ್ರ್ಯಾಪ್ ಆಗುತ್ತೆ, ನವೆಂಬರ್ಗೆ ಬಂದಿದೆ, ಜಾನ್ವರಿಗಲ್ಲ. ಸೊ ಈ ತರ ಮಾಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ನ ರಾಂಗ್ ಮಾಡಿಸುತ್ತೆ ಆಸ್ಪಿರೆಂಟ್ಸ್ ಇಂದ. So these are the things which I wanted to talk about citizenship. This was been asked in the year 2021 because 2019 Citizenship Amendment Act ಆಗಿತ್ತು. So Citizenship Amendment Act ಆಗಿದ್ರು ಕೂಡ ಕರೆಂಟ್ ಅಫೇರ್ಸ್ ಇಂದ ಕ್ವಶನ್ ಬರಲಿಲ್ಲ. It asked the static part of citizenship. So ಅದಕ್ಕೆ ನೋಡಿ, static is the most important thing, current ಅಲ್ಲ less important. Which of the following factors constitutes the best safeguard of liberty? Liberty ಇರಬೇಕಂದ್ರೆ ಸೆಂಟ್ರಲೈಸೇಷನ್ ಆಫ್ ಪವರ್ ಬೇಕಾ ಬೇಡ? ಎಲೆಕ್ಟೆಡ್ ಗವರ್ಮೆಂಟ್ ಓಕೆ, ಬಟ್ ಲಿಬರ್ಟಿ ಡೈರೆಕ್ಟ್ ರಿಲೇಷನ್ ಇಲ್ಲ. ಸಿ ಲಿಬರ್ಟಿ ಇದನ್ನೇ ಬೇರೆ ಬೇರೆ ರೀತಿ ಕೇಳ್ತಿದ್ರು ನೋಡಿ. ಸುಪ್ರೀಮಸಿ ಆಫ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬೇಕಾ, ಅಥವಾ ಲಿಮಿಟೆಡ್ ಪವರ್ ಆಫ್ ದ ಗವರ್ಮೆಂಟ್ ಬೇಕಾ, ಅಥವಾ ಲಿಬರ್ಟಿ ನಿಮಗೆ ಇರಬೇಕಾ? ಸೊ ವಾಟ್ ಈಸ್ ನೀಡೆಡ್? ದ ಓನ್ಲಿ ಕನ್ಫ್ಯೂಷನ್ ಶುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಬಿಟ್ವೀನ್ committed judiciary and separation of powers. See, to protect liberty, most important thing is that the power should not be, all the power should not be in the hands of only one organ. The power should be scattered across different organs of the state, be it executive, legislative, or judiciary, so that one can keep an eye on the other. So for liberty, it is the separation of powers that is needed more than a committed judiciary. Because see, it is telling a committed judiciary will do its work, but if the power is been granted by the constitution itself to one organ, say legislative organ. For example, ಈಗ ನೋಡಿ, parliamentary supremacy, where do we have it? Parliamentary supremacy we have it in UK, we do not have it in India, right? So parliamentary supremacy is present in UK. So ee tara iddaga, even if there is a committed judiciary, if the constitution itself has given power, absolute power to the parliament, then even a committed judiciary cannot protect the liberty, because the power itself has been given to the parliament. Just like we spoke of right to property cannot be protected against arbitrary legislative action, right? Because the power has been given. Likewise, but if there is separation of power, then one can keep an eye on another and no one has absolute power. So this is the answer and not this. So this is one confusing question in actual exam. We'll move ahead. Also see provisions with respect to separation. Article 50. Where did it go? Article 50, Article 121, 211, 122, 212, Article 361. All this deals with separation of power. In India, there is no absolute separation of power, rather there is relative separation of power. This I have discussed in last class also. We'll move ahead. We adopted parliamentary democracy based on British model. Yes, because US, it leans more towards the presidential system. We took parliamentary system from the British. And how does it differ? As regards to the legislation, British parliament is supreme, just like I spoke just now, and is sovereign. But in India, the power of parliament to legislate is limited. This is correct. It is limited by judicial review. It is limited by the constitution. It is limited by the fundamental rights. It is limited by the basic structure. In India, matters related to the constitutionality of the amendment of an act of parliament are referred to the constitution bench by the Supreme Court. There is nothing big in this. This is a correct thing. One more thing which we know, which we need to know is, see, constitutional mention agide, constitutional cases idre, it should be referred to a constitutional bench. Yes, and this bench should have at least greater than or equal to 5 persons heading the bench. 5 judges. Rather, it is 5 judges should at least be 5 judges who will be heading the bench when they are dealing with the constitutional cases. Idu gottirbeku. Indian Parliament is not sovereign, and constitutional cases, as said under Article 145, Clause 3, they have to be heard by bench of not less than 5 persons. So 7 persons could agbodu. When the case is very important, dealing with public interest at large, 7 persons ಆಗ್ತಾರೆ, ಇಲ್ಲಾಂದ್ರೆ 5 ಆಗ್ತಾರೆ. This was another bouncer which was better meant to be left when we are actually attempting this question in the exam. See, ಎರಡು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ. ಸೊ ಗೆಸ್ ವರ್ಕ್ ತಗೊಳ್ಳೇಬೇಕು ಅಂತಿದ್ರೆ, ಸಿ ಇದನ್ನ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದ್ರಲ್ಲೂ ಪಾಯಿಂಟ್ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಈ ತರ ಕ್ವಶನ್ ಮತ್ತೆ ಬರೋದು ಇಲ್ಲ. They are dealing with some 1970 thing which they are very less important as of now, and these are not even in news or anywhere connected for our present day preparation. So N. Gopal Swami Iyengar committee suggested that a minister and a secretary be designated solely for pursuing subject. So ಈ ತರ solely ಅಂತ ಇದ್ದಾಗ guess work ಮಾಡಿ think ಮಾಡಿದ್ರೆ we could have taken it to be wrong. 1970 Department of Personnel was constituted on the recommendation of ARC and was placed under PM. So Department of Personnel on the recommendation of ARC, this seemed to fit in. So ಇದನ್ನ ಕರೆಕ್ಟ್ ತಗೊಂಬೋದಿತ್ತು. ಸೊ ಈ ಒನ್ ಅಂತೂ ಕರೆಕ್ಟ್ ಆಗಿ ತಗೊಂಡ್ರೆ AC ಆಗ್ತಿತ್ತು. ಈ ಎರಡರ ಮಧ್ಯೆ ಏನ್ ಮಾಡಬೇಕಿತ್ತು, 50-50 ತಗೊಬೇಕಿತ್ತು ಡ್ಯೂರಿಂಗ್ ದ ಆಕ್ಚುಯಲ್ ಎಕ್ಸಾಮ್ ಕಂಡೀಷನ್. ಸೊ ಇಫ್ someone has analyzed this 2 statement problem, 2 statement questions since 2017, they would have known UPSC 2 statements ಇದ್ದಾಗ ಏನ್ ಮಾಡುತ್ತೆ, ಒಂದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡುತ್ತೆ ಮತ್ತೆ ಒಂದನ್ನ ರಾಂಗ್ ಆಗಿ ಕೊಡುತ್ತೆ. ನೀವು 3 ಸ್ಟೇಟ್ಮೆಂಟ್ ನ ಬೇಕಾದ್ರೂ ನೋಡಿ, ಯೂಶಲಿ 1 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ್ರೂ ಕರೆಕ್ಟ್ ಇರುತ್ತೆ, 1 ಸ್ಟೇಟ್ಮೆಂಟ್ ಆದ್ರೂ ರಾಂಗ್ ಇರುತ್ತೆ. ಮಿನಿಮಮ್ ಇದು ಬರಲೇಬೇಕು, ಎಕ್ಸೆಪ್ಟ್ ವೆನ್ ಇಟ್ ಇಸ್ ಅಪ್ಲಿಕೇಶನ್ ಕ್ವಶನ್ ಆನ್ ಸೈನ್ಸ್ ಅಂಡ್ ಟೆಕ್, ರೈಟ್. ಸೊ ಈ ತರ ಬಿ ಅಥವಾ ಡಿ ನ 50-50 ಮಾಡಬಹುದು ಡ್ಯೂರಿಂಗ್ ದ ಆಕ್ಚುಯಲ್ ಎಕ್ಸಾಮ್. ನೆಕ್ಸ್ಟ್ ಕ್ವಶನ್ ಇಸ್ ರೈಟ್ ಟು ಪ್ರೈವಸಿ. Right to privacy protected under which article of the Constitution of India? See, Article 29, religious rights. So this is not the answer. Article 19, freedom of speech and expression, association, assembly. This is also not the answer. Right to protect against discrimination, 15. This is a very simple question. Article 21. Article 21, right to privacy. ಯಾದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದು, ಮೇನಕಾ ಗಾಂಧಿ ಕೇಸಲ್ಲಿ they enlarged the definition of Article 21. It said that right to privacy and so on. There are so many other rights. Right against torture, right to healthy environment. All these rights are subsumed under Article 21. But this was said, right to privacy comes under Article 21. This was said in Puttaswamy case. Puttaswamy case ಅಲ್ಲಿ right to privacy is an integral part of right to life and personal liberty ಅನ್ನೋದನ್ನ ಆಡ್ ಮಾಡಿದ್ರು. ಸೊ ಪುಟ್ಟಸ್ವಾಮಿ ಕೇಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗುತ್ತೆ. ಮತ್ತೆ ಪ್ರೈವಸಿ ಬಗ್ಗೆ ಬಂದಾಗ there is this triple test of privacy which we need to know. So privacy na deny ಮಾಡಬೇಕು citizens ಗೆ ಅಂದ್ರೆ it has to pass the triple test. So what is this triple test? See, ಇದು ನಮಗೆ ಗೊತ್ತಾದ್ರೆ ಟ್ರಿಪಲ್ ಟೆಸ್ಟ್ ಮೇಲೆ ಕ್ವಶನ್ ಬರ್ಬೋದು. That is why we will discuss. One is Puttaswamy case which brought right to privacy under Article 21. See, triple test for privacy, it has to pass all this. One, it should be legality. If you want to deny the privacy or if you want to restrict the privacy, then it should be made through a law. One. Second, there should have been a need for it. There should be a legitimate state purpose for which it has been made. And another thing is proportionality, which means that there are no other alternative means available to accomplish this purpose. And even if there are available, they tend to be more harmful than this. So, ee more conditions meet adre matra, then we can restrict the privacy. Also, there is another thing which we need to know. B. N. Sri Krishna committee, which appointed or which made recommendation to protect the personal data protection. But do we have data protection in India? Think madi. Yes, we have, but it is for the digital domain, not for the non-digital domain. Digital Personal Data Protection Act, Digital Personal Data Protection Act 2023. So in the digital sphere, personal data has been protected, but in the non-digital sphere, we are yet to have it. ಇದನ್ನ UPSC ನಿಮ್ಗೆ ಅವೇರ್ನೆಸ್ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ ಕೇಳಕ್ಕೆ ಪರ್ಸನಲ್ ಡೇಟಾ ಪ್ರೊಟೆಕ್ಷನ್ ಆಕ್ಟ್ is present in India. ಈ ತರ ಕೊಡಬಹುದು. It is wrong. Only for digital domain ಇದೆ, ಇನ್ನು non-digital domain ಗೆ ಮಾಡಿಲ್ಲ. Next question. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. ಮತ್ತೆ ಇಲ್ಲಿ ಟ್ರ್ಯಾಪ್ ಕೊಡೋ ಏರಿಯಾ, no law. In 1991 Lok Sabha election, Sridevi Lal contested from 3 Lok Sabha constituencies. Okay. As per existing rules, if a candidate contests in one Lok Sabha election from many constituencies, from his or her party should bear the cost of by-elections of the constituencies vacated by him or her in the event of him or her winning in all constituencies. See, one candidate idane, there is one candidate who will contest from 2 constituencies. So if he wins in both the constituency, then in the other constituency there will have to be by-election, because only one constituency he can be appointed, he can be elected. So other constituency ಮತ್ತೆ by-election ಮಾಡಬೇಕಲ್ಲ. So ಯಾರು ಎಲೆಕ್ಟ್ ಆಗಿದ್ದಾನೆ ಅವನ ಪಾರ್ಟಿ should bear the cost of by-elections ಅಂತ ಹೇಳಿದರೆ, which is not the thing. This is a totally made up thing. Election Commission will bear the cost of by-elections. ಪಾರ್ಟಿ ಬಗ್ಗೆ ಬರದೇ ಇಲ್ಲ ಈ ವಿಷಯದಲ್ಲಿ, ರೈಟ್. 1991 ಲೋಕಸಭಾ ಎಲೆಕ್ಷನ್. ಸಿ ಈವೆಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿದಾಗ ತಟ್ ಅಂತ ಒಂದು ಮೈಂಡಿಗೆ ಬರೋದು ಏನಂದ್ರೆ, there is no law restricting candidates ಬಗ್ಗೆ ಮಾತಾಡಿದ್ದಾರೆ, and ಲೋಕಸಭಾ ಎಲೆಕ್ಷನ್ ಶ್ರೀದೇವಿ ಲಾಲ್ ಕಂಟೆಸ್ಟೆಡ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಿ ಇಲ್ಲಿ ಹೇಳಿರೋದು 1991. ಸೊ 1991 ಅಲ್ಲಿ ಈ ತರ ಆಗಿದೆ. ಸೊ inner mind we can also think of this, that whenever anyone who follows elections, they know that a person could contest from only 2 constituencies. Election follow ಮಾಡೋರ್ಗೆ ಯಾರಿಗಾರಿಗೂ ಗೊತ್ತಿರುತ್ತೆ. So there is no law preventing this from 3 constituencies ಅನ್ನೋದು ನಮಗೆ ರಾಂಗ್ ಅಂತ ಗೊತ್ತು. So in that sense we know 3 is wrong. So answer will have to be either 1 or it will have to be 2, and we know 1 is correct. But how do we accept 1 is correct when we read 2? So ಈ ತರನು ಕೂಡ ಥಿಂಕ್ ಮಾಡಬಹುದು. 1991 ಅಲ್ಲಿ it was been allowed. So who knows, after that amendment ಮಾಡಿರಬಹುದು preventing to happen this. That is what has actually happened. 1991 ಅಲ್ಲಿ this person actually participated from 3 constituencies. But after that, in the year 1996, there was amendment of Representation of People Act, and it limited a person contesting from 2 constituencies. See, that is what Representation of People Act. Later it was been added, and the cost is been borne by the Election Commission. Party by election cost na bear ಮಾಡೋದು necessity ಇಲ್ಲ. So this was all about the 2021 Polity PYQ discussion. Thank you for watching the video.